child in their care as a CPS foster family. The child is Alexandria Sharice Jackson, a date of birth of February 6, 2018. Her parents were terminated in a CPS action in April of 2019. The foster parents have had possession of Alexandria, and they call her Alex, since May 6th of 2018, and they are in possession of her at this time and have been in continuous possession. A suit to adopt Alex was filed by the Williamsons in Hill County, the county of their residence and the county where the child resides, on June 15th, 2020. A copy of that pleading with the court's file mark showing is attached as Exhibit A to the motion to transfer. Motion to transfer the case from your court to the corresponding court in Hill County, Texas, which is the residence of the child and is where the suit to adopt had been previously filed, was filed in your court on June 16th, 2020. From the Williamson standpoint, the rest of the evidence that they developed in support of this hearing by the cases appears to be relatively brief, relatively well known, and relatively set forward. And if the court has read the pleadings, which I'm convinced has occurred because I've watched it happen, and you have previously, then the court is familiar with not only the statutes that govern this, which are 2 in number, but corresponding case law, which interestingly enough arises about 10 years before the statute was passed. I'm not going to make an argument that the legislature was a bit slow in catching up with the courts, but I think it's evident that the case law was well set, well established, and well known 10 years prior to the passage of the mandatory transfer statute, which absolutely by its text applies in this case. And the court really is under a mandatory duty to transfer this case in accordance with the statute. And we're ready to proceed on the evidence when the court's concluded initial statement.
Ms. Neighbors, your thoughts?
Yes, Judge, thank you. We have reviewed the motion as well as the statute, and the issue that the department has is that the definition of this or the standing provision, the residence provision within 155.201A1, which is this new provision that was passed recently by the legislature, says that the child has to reside in the county where the adoption is filed pursuant to section 103.001. And when reviewing 103.001, it is unclear because the venue really places the child's residence where the parent resides. So in this case, we don't have parents technically because we have already terminated. The case law that's cited in the response is 10 years old. And since in that 10-year time period, even since the Neighbors case, the legislature has redefined the role that a foster parent can fill. And we do not believe that a foster parent can be an adult who has care and control, actual care and control of the child, because the legislator specifically excluded that from the standing provisions. So we believe that the legislature intended to treat foster parents differently, the same way that they did when they created a standing provision for them in 102.001, different from A9, but I believe it's A16. I thought I had it in front of me. However, the real issue here is that foster parents are treated differently. They have been historically treated differently by the family code. And we do not believe that the venue or the residence for the child can be anywhere but Tarrant County, because the only people acting as parents and managing conservators of this child have always been the department that's located in Tarrant County. The Williamsons moved to Hill County with the permission of Tarrant County, and we believe that the fault in the new 155.201A1, if it were to be applied as the petitioner's request, would be that it essentially allows them to venue shop. It would be a situation where a foster parent could move to any county, reside there for at least 6 months, and wrest control over a case from a court that has historically heard the case and is more familiar with the case than any new court. Additionally, there was a standing order that was included with the motion to transfer from Hill County. And that standing order essentially puts a protective order so that a child cannot be moved from the state. In this case, particularly, we have been waiting on a Minnesota ICPC. That testimony was developed in the trial for termination back in April of 2019. So all parties have been aware that since April of 2019, the department's plan has been and still is to put this child with her family who resides in Minnesota. They have been licensed now, and there's a motion to modify possessory that's on file with this court. And therefore, we think that 155.201A1 was not intended to be a clause that allows a party to venue shop.
Your Honor, may I speak briefly to that to close argument?
Absolutely, but give me a chance. I'm writing notes that go. I'll have questions for both sides. So,
Pardon me.
I want to. No. I want to make sure that I can listen to you fully and not write and listen out one ear. Mr. Sullivan.
Yes, Your Honor, thank you. Very briefly, Your Honor, our position is that to imply the words foster parents onto a reading of the standing section 103.001 is to torture the legislature text. Those words do not appear in there. The court is being asked, I think, to graft some sort of different duty, responsibility, care, or legal standing onto a foster parent than on any other person when the legislature did not choose to use those words in that section or to limit a foster parent's ability to file a suit to adopt. Quite the opposite. Those words are not in there. That is limiting the foster parent, and the clear text allows the foster parents to proceed on a suit to adopt. I thought I heard that the plan has been to place this child elsewhere than with the foster parents. The counsel was correct that the foster parents were allowed to move from Tarrant County to Hill County, the county of residence of the child, for the last over 17 months, and that the plan was, in view of that move, to allow the foster parents to adopt. Quite frankly, those facts are not a part of these proceedings. The question set out in the statute is clear. Number one, has a suit to adopt been filed? That is the mandatory transfer provision of 155.201A1, which trumps any other section referring to foster parents, since the words foster parents are likewise not in that section. And more importantly, these foster parents, the Williamsons, are in the sole care, control, and possession. Notice the word custody is not contained in the standing section. It is care, control, care, custody, care, control, and possession. Custody is not contained in that section, and they are the sole parties which are in possession of the child, and the child has been continuously residing in Hill County for over 17 months. By the way, the legislature, in adopting the change to 155-201, making this transfer mandatory, we believe, adopted the view of the case law about which there are significant cases, principally the Neighbors case out of Houston in 2009. The legislature did not vary away from the findings in Neighbors or the two underlying cases which precurse Neighbors, that would be Kirst, K-E-R-S-T, out of Texarkana in 2007, and Gore out of Amarillo in 2009. All of these cases arriving at the same conclusion, and that is that this prospective adoptive couple, having had the care, possession, and control of this child for a period of over 17 months in Hill County, and certainly in excess of 6 months, renders this transfer mandatory, and the discussion of what the department's plans are or not, although perhaps useful as background, don't bear on the text of the statute whatsoever. In effect, what's being asked is for the court to consider the same arguments that were given in Neighbors, Kirst, and Gore, and rejected uniformly by all of those courts, and then rejected by the legislature in adopting the mandatory transfer section. We believe that transfer is controlled by 103-001B and by 155-201A1. There's nothing left to guess at because the text of the two statutes is clear, and I believe that those texts will in fact guide the court in regard to entering the order of mandatory transfer that we transmitted to the court yesterday for consideration and entry. And we're ready to proceed with evidence at this time.
Did Judge Kim froze? No. I'm sorry. I thought you froze.
Very intently reading something. So I have some questions. All right, so Mr. Salmon, and this kind of, and this is the part that's getting me right now. I understand your argument. My thoughts is, it seems like a lot of this hinges on the residency, because the parents obviously are terminated, right? And so there's not an issue about that. The conservatorship is with the department. Now, residency is going to be a key issue as far as whether it's appropriate to file the adoption in Hill County or not. Because if the child wasn't a resident of Hill County, then there's no reason why the case would be filed there. But if an adoption can be filed for a child anywhere where the child is physically present, I mean, what if the child was in the RTC? Like it's a CPS case and they're placed in some kind of facility. does that mean an adoption can be filed wherever the child happens to go and is for 6 months?
I believe so. The actuality of this is that the transfer hinges on the suit. The suit may be filed anywhere that the child is in residence. The reading that's perhaps being argued for, or that I heard being argued for, was to limit the consideration of the legislature and to say the child is not in residence where the child is in residence where the department is. And that's just simply not the statute. That's not what's contained within the statute. A suit for adoption can be filed anywhere that the child is in residence for a period of 6 months. That would be Hill County. The suit, more importantly, once filed, requires under 155-201A1 a mandatory transfer if the child has been in residence, but that issue has really already been decided by the suit being filed, or at least that's the legislative scheme and the legislative mandate contained in the statute. Once that suit is filed, to say that the child is not in residence in Hill County begs the issue contained within 103-001 and 155-201, and in fact does injustice to the clear wording of the text of the statutes, both of them. These are not new arguments, Your Honor. The cases which have been cited by both parties say one thing, and that is that prior to and subsequent to the passage of the statute, this matter of transfer was one that was governed by where's the child physically located. These arguments have been made before as early as 12 years ago, 13 years ago, to various courts of appeals, and they've all failed every single time. The legislature amended the statute on transfer to match what the courts were telling the legislature to do.
So, Mr. Stillman, these are all cases involving children in conservatorship with the department.
Yes, sir. Every single one of them.
Can you send those 3 cases? Neighbors, Kirsten, Gore. Do you happen to have those electronically? You can email to me.
We don't have them in here, Your Honor. Let me, in explanation of my answer, we're in a conference room on an upper floor of our office. We had a positive case of COVID come in yesterday, and the floor that we work and operate on is closed to entry while it's being disinfected at this moment. While this hearing is progress, we can get those people out of that floor and get the use of that floor.
Can you give me the citations?
Yes, sir, absolutely. The earliest case is Kerst, K-E-R-S-T. The citation is 237, Southwestern 3rd Series, 441 at 442. That is a Texarkana case in 07, which is an original proceeding. All of these are original proceedings. The issue under consideration by the court is addressable in an original proceeding. The second case, which is cited in the neighbor's case, is Gore, G-O-R-E, at 2007, Tex Appeal Lexus 6814. That's an Amarillo case.
You said 6814?
Yes, sir, I did.
Okay.
And the third case that appeals to congeal the rulings of both of those prior cases and then restate it by emphasis is the Neighbors, N-A-B-O-R-S case at 276, 3rd Series, 190, which is a 2009 Houston 14th case. And we will be able to transmit those electronically probably within about 30 minutes as soon as it gets, the air gets clear enough for us to get down there.
So Mr. Solomon, I guess another question is, so when foster parents get licensed by the state and they agree to become a placement for children in the conservatorship of the state of Texas, naturally we can agree that they give up certain rights, like they give up their right to bear arms, they give up their right, all kinds of things, certain religious speech, free speech issues. These are waived rights by foster parents. It was always kind of my understanding that the foster parents are waiving their rights as what a normal adult would be in the state of Texas by saying, we're taking these children, but now we're being classified as kind of for lack of a term, a lesser class of an adult, which is why there's special standing requirements for foster parents and different things. It was always my understanding that for foster parents, it was more difficult because they didn't have the full rights that a normal adult would have when it came to have standing for, let's say, for intervention in a lawsuit, right?
Yes, that's correct.
So would you disagree that this doesn't apply, that when foster parents take a child in conservatorship from the department and are loving this child and taking them into their home, that they are now kind of relegating themselves where they're saying, we don't actually have the child here. It's not our child, it's a state's child. We're just kind of housing this child. Is that, I think you disagree with that, but I'd like to know why you would disagree with that.
I disagree with that fundamentally, Your Honor, because the traditional headline standing provisions of Chapter 102, and that would be 102.003 and 102.009, which both do mention foster parents, have no application post-termination to an adoption suit. There are specific statutes that have been written with regard to the filing of adoption suits, with regard to persons who can file, and with regard to where those suits can be filed, which do not include the limitations on a foster parent. If I might, Your Honor.
Hold on a second. Before you go forward, because I'm trying to keep up with you. So we'll go to 102.03.12. Right?
Yes, sir. That particular provision has no bearing on post-termination actions to adopt a child. Those have to do, as the court correctly pointed out when the court was asking the question, those have to do with the filing of suit, intervention in suits, and maintenance of suits with regard to an unterminated child or with regard to the issues of conservatorship. They do not have to do, that standing statement in both 102.003 and in 102.009 have nothing to do, respectfully in our opinion, Your Honor, with regard to suits to adopt post-termination. Those suits are under special statutes.
What would be the authority saying that 102.003.12 doesn't apply in post-termination proceedings?
Your Honor, it's our position that a clear reading of Neighbors, Kirst, and
Okay.
will explain that and explain that we're really operating on a different standing / right to file plane than the foster parents were admittedly operating under pre-termination. It's a different plane, and it does not apply to this action.
That's fair. I need to do those cases. All right.
Yes, sir.
So, Ms. Neighbors, my question for you. So, and this is more of a policy question, but if there's an adoption motivated foster parent that didn't live in the county where the termination was, what would ever motivate them to take a child into their home? If the purpose, if they're adoption motivated and they're like, well, there's a great child, looks like a great fit, we'd love to foster, but we live in Johnson County. And so, we're not going to take this child because this can't end in adoption unless we go back to Turner, or let's say they're in, Fort Stockton or across the state. Doesn't it seem like, as a policy matter, it would behoove the department to get adoption motivated people, no matter where they are in the state or out of state, without being able to block them, saying, hey, look, you're not going to have standing to adopt this child unless you're actually here.
Well, they would have standing to adopt the child under 102.003A12 as long as they've had the child for 12 months. It's not an issue of standing, it's an issue of discretionary transfer. And, you know, I think that our entire argument hinges on the idea that we do not believe that the child resides in Hill County under 103.001 because the only reason she's found in Hill County is because of the contract that the foster parents have with the department. The department has allowed them to be there.
Right,
so
get that argument, and I need to read the three citations.
Yes, and may I point out that all the cases that have been cited, and this is something that I looked into extensively, these are not out of the Second Court of Appeals. So we don't have any guidance on what the Second Court of Appeals would do. These are appellate cases, they're not Supreme Court cases. But to answer your question further, they can adopt, and at any time a court has the authority to transfer. It's a discretionary transfer. And I would assume that in the instance where this is a clear-cut adoption, we don't have any family members that we've been home studying and getting licensed or ICPC for months, we have a child who's ready to be adopted, because we do have those duties to follow through with these familial placements and to explore them, because it is important that the child be with family. So if you have a case where a child simply doesn't have any family and you have an adoption-motivated home, I would assume at that time the department would not oppose the motion for transfer, because it is a discretionary transfer under B. So it is not a question of why would a foster family take a child. Whenever a foster family takes a child, especially a child that they are aware there's existing family members who need to be home studied because we have to follow our ICPC protocols, you know, when you take a child into your home, it is an act of love, but it is not necessarily going to be an act of permanence. And we try our best to inform our foster parents of that anytime that they take a child in. We've had issues in the past where we've had foster parents who we believe were acting inappropriately because they were promising permanence to a child who we had every intention on placing with family once we got it cleared through the court system or through ICPC. And that creates a big problem for children. Children who are well loved, they bond well, they will do well. And we're very fortunate that we do have these foster families who are willing to take these children in and, you know, raise them and care for them. But it is a contract, and that is the only reason why a child would be found in another county. So my answer to your question is that I would assume in that type of situation, the foster family would be aware that there would be a large possibility that the child would not remain with them, or that the department would simply not be in opposition to the transfer. And in this case, not only is the department going to be in opposition to the transfer, but due to our approved ICPCR, the department's going to be in opposition to the adoption.
Which is going to be my next question. The department is going to be in opposition to adoption. Mr. Salmon, I mean, that's going to be a situation in of itself, right?
Yes, Your Honor. And under the transfer statute, number one, I agree with counsel that the limitation on the foster parent no longer applies under Chapter 102, simply because there has been a termination completed, and now our clients, the Williamsons, stand in the position of an adult who has had the possession of a child under Chapter 160 who may now file a petition to adopt. They filed in their home county. I've avoided speaking to the issue that was raised earlier about forum shopping, and I don't know precisely why that issue was raised, but counsel did say, and I do agree.
I'll interrupt. I'm letting you know that the forum shopping argument is not persuasive with me. I got just not. So
thank you, Your Honor.
Don't worry about that one.
I'm just addressing things out of an abundance of caution. At the end of the day, these same arguments that are being made by counsel now were made in front of 3 different courts, and though the second court has not spoken to it, I cannot imagine that the second court, in view of the statute confirming the other 3 courts of appeals findings in original proceedings would vary in any way whatsoever. The court is a textualist, conservative court in my past experience in Tarrant County, and will stick with the statute as written. And if the court sticks with the statute as written and the underlying case law, then this matter would be a mandatory transfer. It is not a discretionary transfer. The statute is clear, the wording of the statute, and to say to amend on to the statute that foster parents in some way are disabled because they had a contract with the department that fundamentally changed at the moment of termination, and they have a child in their possession that the department said, take to Hill County, be in Hill County, the child will be in Hill County, we'll assign a courtesy worker in Hill County to evaluate and test this home, and the child is placed with you in view of an adoption. It is fundamentally different than what counsel is attempting to get the court to understand as some exception to mandatory transfer. Mandatory transfer is clear under the wording of the statute. These foster parents are not disabled, and I believe that our discussions regarding foster parents being disabled from either A, proceeding, B, filing a suit, or C, pursuing the suit in the county of their traditional, habitual, and permissive resident simply begs the statute and asks the court to imply something into the statute that is not written there. And Your Honor, I'm asking the court not to do that, not to read something into the statute that simply is not a part of the legislative mandate or the cases underlying it.
All right, so here's where I'm at. I think, y'all, Ms. Neighbors, Mr. Sullivan, y'all have answered the questions that I had. So what I do, so this is my personal judicial philosophy. If it's ever a question of fact, all the litigants deserve a decision on the spot. It's just my job to process facts as quick as I can and to make decisions on the facts. I shouldn't delay that because all the facts are presented to the court. However, if it's a question of law, I think I have a duty to ensure that I understand the law as it's written, okay? And whether it's the statutory or with case law. And at that point, I feel like I have the discretion to hold off on a ruling to ensure that I'm actually following the law. Okay? What's interesting to me are these three cases out of Amarillo, Harris County, and Texarkana, and making sure that they fit in. I don't think there's a question of fact and any questions of fact at this point. I do have a detention hearing that's coming up. I need time to find these cases, to print them out, and to read them. So can we reconvene at 1:30? Is that fair enough? Does that work for with everyone's schedule?
Works with ours, Your Honor.
I mean, I can just render a ruling and email it, but I think everyone deserves to hear me, make the decision, explain why I'm making the decision.
Your Honor, the underlying cases do indicate a need for evidence with regard to the underlying facts. That is the period of time that the child has been in the county where the adoption suit is filed, with regard to the termination having previously existed and the
well, Mr. Sullivan, I'll take judicial notice of the court's record, which has the permits review orders in there. That should give me a background on the children, if that assists you. And then I think probably all three cases indicate that I think everyone here can agree and stipulate that there probably should be a little more clarity in these situations when there's a termination, conservatorship with the department, and a foster placement. I mean, I think we are Mr. Solomon, it seems like your argument is based on the plain meaning of the statute. And Ms. Neighbors, as you're saying, well, as much as I know you, Ms. Neighbors, and that you're fond of the plain meaning of the statute, it seems like there's just kind of a void that's not being addressed, where it seems like your argument is saying you can't really apply the plain meaning when the legislature failed to explain how this applies in this situation, which is a fairly common situation. And I think that's where the disconnect is. Correct me if I'm wrong, but that's my interpretation of where the major disconnect is between the parties. So, okay, so I just come back, same Zoom channel, 1:30, and then at that point, that should give me enough time. If it looks like these are very lengthy appellate opinions, then I can let the coordinators know, to let the parties know that we may push it back. Just give me time to read. Okay?
Your Honor, we're
Thank you,
going to
Judge.
be able within the next 5 minutes to get into our offices. Would the court instruct us to send copies of these cases to both you and to counsel?
If you could, that would actually make things quicker for me. So I would appreciate
Will do.
that. Okay.
We'll do that. It looks like the crew's leaving right now, so we'll be able to breathe down there in the next few minutes.
All right. Thank you, Mr. Solomon. All right. Thank you.
Your
So
Honor.
we are in recess on this matter.
All right,
Indeed.
thank you, Judge.
1:30. Ms. Neighbors, do you mind telling Ola that? I think she logged off, but she was holding up 2 fingers. So she may think it's 2, but I meant 1:30.
She's
Okay.
still open on our channel.
I'll make sure to let her know.
All right. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you.